Passing the threshold of that second test, the majority found that local leaders were involved, businessmen, politicians, members of the police force. And there were retaliatory attacks within the Rift Valley and Nairobi using the Mungiki against the ODM. There was organisation between politicians, businessmen and Yobs. There was inflammatory rhetoric, and how they were carried out in relation to the attack showed that there was a strategy or method. The next significant test in relation to crimes against humanity is whether it is a widespread or systematic attack against the civilian population. Widespread, the court found, encompasses the large-scale nature, number of victims. And in relation to Kenya, this test was passed when events in Kenya took place on a large scale. Over 1,000 people killed, many injured, 350,000 displaced, an increased number of rapes and sexual violence in the attacks. You have to consider the nexus between the individual acts and the attack. You must consider the nature, aim and consequences of each act, whether they were directed against the civilian population, widespread and systematic. Isolated acts which differ, so happening in different places, burning here, rapes here, in the above respects from other acts forming part of an attack are not within the scope of Article 7.1. And then the court found initial attacks against the Kikuyu population by the ODM. They were displaced. There were retaliatory attacks against the Luo, Kalenjin community, and as a result of that, people were moved out of their area. Judge Call, the third pre-trial judge, had a dissenting point of view and issued a dissenting judgment. And this is a useful exercise, in my view, to introduce you to the subtleties of some of these concepts. He said the English version of the statute leaves aside the question of specific authorship of policy, state or organisational policy. Where does that policy come from? He said the English language doesn't define who it has to be the creator of that policy. He said this allows a wide interpretation that a state may adopt a policy or an organisational policy may simply be found to exist. However, you get this in international law, they refer to other translations of the main document to see what they say in French, here French, Spanish and Arabic, the other three languages of the International Criminal Court, and they gave a more limited interpretation of the word organisational and a more precise definition in the Arabic, French and Spanish words going to the authorship of the organisation, who was responsible for it, and the definition of what that organisation was. He referred to that issue of organisation, the policy that must exist, linking that word policy with organisation was how he got to authorship. Criminal conduct attributable to a state or organisation which at least is endorsed as a policy, so it must be accepted as something that is going to happen, not just being something spontaneous, but this policy carries with it an interpretation of intent, rather like John's JCE point, that it has an intent or purpose that is clearly defined, although not in his case. He said that there should be a higher threshold than the majority of judges had found. The determinant of organisation is not whether it has that capability to perform acts which infringe on basic human values. His point being was any group of yobs could fit the definition of the majority from their judgment. That it was far too loosely described by them and open to extending the net of the prosecutor, so that virtually the court was being turned into an overall human rights court rather than a court dealing with the specific issues upon which it was founded in 1999, which was over state or organisational policy crimes. He believed the organisation required some elements of a state to have a collectivity of persons, common person, purpose, a period of time that had longevity, hierarchical command structure, with a policy level, so far more definite than as the majority of the judges found, and the capacity to impose the policy on its members. Not necessarily having the power to sanction, but being able to impose it in some way, shape or form. Threat, duress, something like that. And the capacity and means to attack any civilian population on a large scale. He said the demarcation line must be drawn between international crimes and human rights infractions. He thought the statute of the court was being trivialised and must avoid being made the subject of a banal interpretation. So a pretty strong and hard-hitting decision, you may think, against his fellow judges. And intervention should take place in limited cases where the crimes are of concern to the international community as a whole. The group possessing the characteristics which would be beyond the ambit of the statute, violence-prone and formed on an ad hoc basis, gangs just getting together to commit retaliatory attacks. So none of this business of, oh, you can have a conspiracy in a second or a conspiracy in an hour. Something far more solid and tangible that fits an international jurisdiction rather than a national jurisdiction. He's requiring this to be a far more definite, focused and determined effort to commit those crimes against humanity rather than the looser definition of his brother judges. And here there was a lack of structure and policy making on behalf of the participants in the particular violence in Kenya. So there you are. In my view, an interesting introduction into what it's about, crimes against humanity, what issues there may be around it, how it differs from the work in our national jurisdictions, and how the subtleties of the law, as applied and considered by judges, can see them moving from the language of the statute to the alternative versions in Arabic, French, and Spanish. So thorough arguments, I think, are needed if you want to get home your position against a prosecutor. You've got to cover all your bases. I'm now going to hand you over to Toby Cadman. Thank you very much.